Viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking about the case of Leventris and Terry. Now, Don, there was an interesting point about causation. What is causation first?
Well, causation is, what's caused the injuries. In this case, you had two collisions. The first one where the plaintiff hit the car in front, and the second one, the defendant hit the plaintiff's car after the collision. The expert evidence came out that it said that you're more likely to suffer injury when you're hit from behind rather than hitting a car, in terms of hitting the car from behind. So the plaintiff in this case was taken that the second accident, when she was hit from behind, would have caused more harm than the first accident when she hit someone else from behind.
Does that sort of stand to reason? I don't
It does, I would think so, because if you're hit from behind, you're not prepared for the impact. But if something's coming at you, you might be able to prepare for it.
So you brace yourself?
Potentially, or loosen up, whatever the case may be.
All right, and so what was the final result? She didn't get much, did she?
Not an awful lot, just some damages to cover the past losses.
Well, the judge took over 12 months to make a decision and she died in the intervening period, which is very disappointing, I think.
Look, it was disappointing in this case, and look, unfortunately, she could have been substantial amount she could have got if she was still alive.
But if, obviously, there would have been evidence about her not being well and that her lifespan. So even if she had survived, it would have been a very small figure for pain and suffering, I would have thought.
Yeah.
Let's go on to the next case of Nikolowski and Holloway. Rob, have you got the facts of this?
I do. Tony, where do we begin with this one? This one is a comedy of errors, this case. The facts are fairly straightforward. Mr. Nikolowski was driving his car and Mrs. Holloway was driving behind him. He proceeded to turn right at an intersection. Now, the intersection he was turning into was a two-way carriageway with a break in the middle. So he was able to drive across the first lane, stop in the middle before he proceeded into the turn. Now, Mrs. Holloway didn't realise that he was stopping in the middle and she collided with the rear of his vehicle.
He's not a good driver, that's for sure.
He's not a good driver.
There was a lot of evidence about what this guy was capable of doing and not capable of doing, and there was a lot of surveillance.
Yeah. Well, look, he claimed he injured his neck and his right shoulder. His right shoulder had a rotator cuff injury. It was a tear of the supraspinatus, so it's a tendon or it's a tear. He claimed that he couldn't do a lot of things to all the doctors that he had seen. He claimed he couldn't move his right arm, he couldn't move his neck, but then they got films and lots of film and footage of him doing a lot of things that you couldn't do.
Well, stop there. He had a lot of pre-existing claims, didn't he? Involving shoulders, neck, back.
Yep.
And if I'm not mistaken, Rob, what, about 3 or 4 claims prior to this accident?
Yes, several claims prior to this accident.
Involving the same body parts?
Involving the same body parts.
And so he's trying to embellish these injuries?
He did. Look, he did try, and they did say he was malingering, because the footage of the surveillance footage was quite damning to his case. They showed him carrying heavy things, even after he was told all the doctors couldn't even remove his right arm effectively. They caught him actually, at one point the judge kept harping on about, was saying that he could not wear T-shirts, he couldn't put his arm around, and he could only wear button shirts, but in the actual film, he was wearing T-shirts.
And also, Rob, in this one, his doctor was given certificate to say he can't lift over certain weights.
That's right.
And he's mucking around with trailers and...
He was carrying trailers, he was carrying wood. Even when he was talking to the judge, he was waving his hands around wildly. It just was completely inconsistent.
I think the amount of surveillance they took on this bloke, they could have done a mini-series.
Oh, absolutely. I think they ran out of time.
Look, but the question in this case was causation. Did the injuries, or did the accident cause the injuries that he complained of? And the judge found that it was a low-impact collision, a very low-impact collision.
The guy that hit him was only doing 15 kilometres an hour.
It was only doing 15 kilometres per hour. They had, again, expert evidence to say, could that cause an injury? Look, a lot of the expert evidence that came out did say, well, look, it was a very low impact. You wouldn't expect these type of injuries. Having said that, the judge did find that he did sustain for a period of time an aggravation of a neck injury, dismissed the right shoulder injury altogether, but did say, the neck injury was as a result of the accident to a certain degree and extent.
Well, just on the point of surveillance, the judge said, I find that the surveillance film is reliable evidence of Mr. Nikolowski's physical capabilities and shows a greater capacity to engage in physical activities than Mr. Nikolowski portrayed to his doctors. So, I mean, the judge didn't like him.
No, not at all.
Bottom line.
No.
So what did he get, Rob?
Well, he didn't end up getting much. As the judge accepted that he had some degree of injury to his neck for a certain period of time, which resolved after maybe 18 months to a couple of years, he got some loss of earnings for the past and some special payment.
Not much.
Not much.
But look, Tony, at the end of the day, I mean, this was a rear-end collision that occurred, and all rear-end collisions do result in injury, in my view. I mean, we're not driving bumper cars or dodgem cars. There's metal, there's tons of metal hitting another ton of metal. And in this case, ultimately, despite his I guess, untruthfulness and exaggeration. The judge did say, well, he did have a neck injury as a result of the accident and did award him some damages, albeit very minimal. And he won his case effectively.
Don, he only got $16,482 for past loss of earnings, superannuation $2,000, interest on past earnings $4,000, and special damages $829, and he didn't get any general damages, pain and suffering.
He couldn't get any general damages because the judge assessed it at around $16,000, and the minimum in Western Australia is $17,000. So had the judge assessed it at $17,000, he would have got $17,000 pain and suffering for someone who, unfortunately, has exaggerated or lied.
It's a very small judgment, isn't it?
It is a very small one.
And we don't really know if there was an offer of comp, because if there was, he wouldn't get his costs paid. In fact, he'd be paying costs.
It almost seems like it would have been worth his while.
No. By the time he pays solicitor client costs, there wouldn't be much money left over. Let's get on to the case of John Evans and Hudson Building Supplies. Who's going to give me the facts of that one?
I can help you with that, Tony. So this case is, again, we've got another one of these rear-ending collision cases. We have 3 big rigs that are travelling along the road. Mr Nunn is driving the rig at the front. Now, the facts show that he proceeded to turn right at a turn. The vehicle travelling behind him, driven by Mr Forth, collided with the rear of his, and the vehicle behind that collided with that vehicle. Now, the facts seemed at the trial to show that Mr Nunn hadn't used his indicator and perhaps that the brake lights weren't working and he hadn't given enough time and warning to the cars behind, but on appeal that was turned around.
What did the court find, Don?
Well, look, the court remitted this back to the District Court of New South Wales. The Court of
Is the
Appeal
District
found-
Court the equivalent of Melbourne's County Court?
I believe so. And the Court of Appeal just said there was no basis in which the trial judge could have found what he did. The trial judge...
But what did he find? What percentages did he attribute to
in
each?
terms of, 60% to Nunn, so Nunn
And
was
where
the
was Nunn?
front,
He was at the front of the line.
Okay.
and 20% to the middle one,
Which is Mr Forth?
fourth, and 20% to the one that hit him at the end.
Mr Dye.
That's correct.
So he
That's right.
attributed 60, 20, 20. The Court of Appeal didn't like that, did they?
Look, the Court of Appeal didn't like it. The Court of Appeal, for the reasons that he gave, the Court of Appeal did indicate that, in fact, Mr Nunn indicated too late. It indicated 20 to 30 metres away from the intersection, which Court of Appeal indicated that's probably a basis of negligence. But the trial judge did not find that. The trial judge said that he didn't have his brake lights illuminated or didn't have his indicator on, which wasn't consistent with the evidence at the trial.
To a layperson and to the viewers, this attributing liability 60, 20, 20 seems pretty subjective. Is it subjective, Rob?
I would think so. I think on that initial assessment, I would have looked at things a little bit differently potentially, because I would have thought that the cars travelling behind should have left enough distance that even if there was some kind of error up front, they could correct that by slowing down.
Okay, look, we're going to have to go to a sponsors break. And I want to thank you for coming on board, Rob.
Thanks, Tony. Always good to be
And
here.
after the break, viewers, we've got the mailbag, so please stay tuned.